Hi, I'm Joe Barucki of Weber Gallagher's Mount Laurel office. I'm joined today by my colleague Vanessa Mendeleski of our firm's Warren, New Jersey office. We want to thank you for taking the time today from your busy schedules to join us. We also want to wish you and your families a wonderful holidays and all the best for a great 2017. Our topic today is on defending motions for medical and temporary disability benefits. Just as a refresher from some of our earlier programs, medical benefits are one of the three benefits that are provided to injured workers. That's covered under NJSA 34:15-15. The insurance company and the employer controls medical treatment. Your objective when controlling treatment is to cure and relieve effects of injury, as well as to restore function where possible. Now remember, if you don't provide medical treatment and you're requested to do so, the petitioner can seek treatment on his own and request reimbursement for it. So you have to be really careful in terms of whether or not you're going to deny medical care. And when you're choosing the medical provider for it, be really careful, because you want to make sure, especially on cases that you think could be complicated or big, that you choose a quality physician at the start of medical care and not just go through the clinic. So you want to make sure that you have reasonable billing and responsiveness of providers and that they understand New Jersey law. Now, when you provide medical treatment, you have to provide it until the petitioner reaches what's called maximum medical improvement. So you have to provide it until they reach that stage where basically they reached a medical plateau, where they reach the highest level of care, of recovery that they can reach, whether it be completely better or to the highest level that they can reach, at which point the doctor discharges them. You have to provide them with all of it, but you want to make sure that when that treatment is being provided, that your physician himself understands the role that the employee has with the company, his job description and function, so that way you can make sure that at the conclusion of treatment, that if there are any permanent restrictions, that they're well defined and well understood. If there are restrictions that the employer can't meet when the petitioner reaches that medical plateau, there is the possibility that you can allow the claimant to no longer have to work for you and relieve him of his job responsibilities. The second benefit that the petitioner can receive when injured on the job is temporary disability. In order to receive temporary disability, you have to be out of work due to a work-related injury or disease. They're only paid to the claimant if the claimant is unable to work for 7 or more days. The payments begin on the 8th day, and those payments themselves, or the days that they miss, do not have to be consecutive. They just have to be cumulative. So you could have a claimant who misses 2 days, a couple weeks later misses 3 days, and then misses 3 or 4 more days after that. Once they reach that 8th day, you have to provide them with temporary disability going back to the first missed day. In order to receive temporary disability under the New Jersey laws, a worker must be temporarily totally disabled. He can't get temporary disability if the doctor finds that the petitioner can work light duty and that the light duty can be accommodated by the employer. If there is light duty, it's available to the claimant and it's offered to the claimant, and the claimant refuses to take it, then an argument can be made to not have to pay them temporary disability benefits. Now in New Jersey, there's no actual defined partial temp. There was recent case law that came down on a judicial level by Judge Cox in Camden called Soto versus Hers, that talked about where a claimant was placed onto a light duty status that gave them less hours than the hours that they were previously accustomed to working. But that case has not gone up to the appellate division. There are many instances, though, where you should talk with your defense attorney, because frankly, we don't want to have bad case law that comes down that mandates you to have to do more than you necessarily have to do. Other things that you should be aware of: if the claimant is a full-time student and working part-time and gets injured and doesn't go out of school, we make the argument that the petitioner is not entitled to temporary disability benefits. Also, if the claimant is working 2 jobs and can't work the full-time job because they get hurt at the part-time job, or vice versa, the argument is that the claimant would get temporary disability from the job where he was hurt, he or she was hurt, and then would get state temporary disability benefits from the other job itself. Temporary disability in and of itself runs until one of three things occurs. One, if the claimant is significantly injured and reaches a point where there's 400 weeks of temporary disability that's been paid, that automatically then transfers and presumes that the petitioner is totally disabled. Second way that temporary stops is if the claimant returns to work. And finally, and that could be returned to work either in a light duty or full duty status. Once they get back in a work setting, then temporary disability in and of itself should stop. And then the third way, and sometimes will run hand in hand, is if the claimant returns to work and is deemed to reach maximum medical improvement and will no longer have curative medical care that will take them to the point where they need additional treatment. Temporary disability is based upon a New Jersey calculation that's done by the Department of Labor. The Department of Labor takes statistics from all registered employers with their employees, and they look and they determine that there's a benefit of 75% of the weekly benefit and the minimum benefit of 20% of the state's average weekly wage of all New Jersey employees. For example, in this calendar year, the 2016 temporary disability minimum is $232 per week, and the temporary disability maximum is $871 per week. If you have an injured worker who is a part-timer and making less than $232 per week, then you basically want to get that person back to work as quickly as possible because they could actually make more money on temp than on medical. I'm going to hand it off now to Vanessa to talk to you about motions for med and temp and the filing of them.
The basis for the filing of motions are they are a contested claim, first off, and they're more likely to be due to medical issues than temporary disability. Medical issues being if the petitioner received authorized medical treatment, was MMI'd, then went off on their own and received unauthorized treatment. Their unauthorized doctor is now recommending some form of treatment or procedure. Their attorney might file a motion for med and temp. The motions are emergent in nature. There are actually two types, which we'll get to a little bit later: emergent motions and general motions. And it should be known that some claimants' attorneys are fee hungry, meaning when they file a motion, they are entitled to a certain percentage of any medical or temporary disability benefits paid as a result of the filing of the motion. So some of them just file motions off the bat just to get additional fees. Again, the motions are due to routinely disputed medical issues or if treatment is proper. In the instance of the injured worker being found to be an MMI, undergoing unauthorized medical treatment, their unauthorized doctor is recommending a procedure. Is that procedure proper treatment for this injured worker's condition? And there's also other issues of premature cutoff. The petitioner is treating, you send them for an IME, independent medical exam, and based on the IME, treatment is stopped. Petitioner's attorneys will file motions if they believe medical treatment was prematurely cut off due to the IME. Also, motions for medical and temporary disability benefits look at curative versus palliative treatment. Curative, it's medical treatment that cures and relieves. Curative treatment is the treatment that puts the petitioner back to the condition they were prior to their injury or close to that condition or function. Palliative treatment comes in the case of chronic pain with pain medication and having to be on pain medication for that chronic pain, so it's palliative in nature.
Just be careful also in regard to the IMEs. A lot of times you'll see carriers that will almost predetermine that they think that the claimant has received enough treatment, or that they wonder why or not the petitioner continues to have to get additional care. If you're going to go out and get a second opinion for something along those lines to make sure that the treatment itself is appropriate and whether or not it should be ongoing, make sure that you speak to your defense attorney ahead of time so that you can pick the right doctor. There are a lot of instances where carriers will go and they'll go through a network and they'll get a physician that will come in and basically give them the opinion that they want. That in and of itself can trigger distrust with claimant's counsel. It can trigger distrust with the court, and it can bring extra motion practice. And we'll talk about it later. And one of the things that you have to be really careful about is extra motion practice causes extra litigation costs for you, as well as exposure in terms of additional medical treatment, temporary disability, and possibly counsel fees for extra motions. So just be real careful before you start making unilateral decisions that you think that the claimant has reached enough medical care.
And there are two types of motions for med and temp. The first being emergent motions. These must specifically show why they are emergent. There has to be a medical report noting that the petitioner is losing life or limb, and any delay in the treatment will cause harm to the petitioner. It has to be irreparable harm, along with how the harm would be irreparable. Simply saying the petitioner wants physical therapy or some other form of treatment is not enough. It has to show irreparable harm. Now, this motion must be faxed within 1 day of service. The respondent has 5 days to file an answer to the emergent motion. After that, the respondent has 15 days to schedule the medical examination. And the courts take emergent motions very, very seriously. All motions are taken seriously, but motions where there's irreparable harm to the petitioner if treatment is not provided are taken far more serious and can be listed on a faster basis than any other type of motion. So if the emergent motion comes and the issue cannot be resolved, it's a continuous trial where you'll have the petitioner come in, the doctors, any witnesses. So it's a continuous trial to try and quickly move the matter.
And what we mean by that is, for those of you who have workers' comp experience, I'm sorry for making this overly simplistic, but we work on a cycle basis where we're going to court on an every 3-week time frame. If it's a general motion for med and temp, which we'll talk about next, we would take the petitioner's testimony on 1 day and then take a lay witness in 3 weeks, and then a doctor 3 weeks after that, and then another doctor 3 weeks after that. Continuous trials are almost like superior court actions where the judge would bring the claimant in on Monday and either make you bring in the lay witnesses on the same day or bring them in on Tuesday and then the doctor in on Wednesday. So because of the emergent nature and the seriousness of the allegations that are being brought, that the claimant needs this treatment or the big time problems are going to occur to he or she as a result of this particular medical condition.
And with regards to emergent motions, at a recent court conference, the director of the division, Judge Wotanko, indicated that an inappropriately filed emergent motion could affect the overall counsel fee at the end of the case.
He found it, he actually kind of went off on the audience because there have been people that, the way he described it is they're trying to jump the line. And they're filing motions for emergent care that really aren't emergent. He indicated that, number one, as soon as they get an emergent motion that gets filed within a vicinage, they referred to it as going to DEFCON 1, that basically everything stops, that the motion in and of itself is looked at with a fine-tooth comb to make sure that these motions are being heard appropriately as quickly as possible and being dealt with as quickly as possible. And the fact that these motions, if they're filed inappropriately and they're really not emergent, are causing undue stress upon the court, he indicated that there could be repercussions not only to the employer if they're not providing the care in an appropriate manner, but also to claimant's counsel if they're trying to jump the line.
The second type of motions are what's considered to be general motions. They're just motions for temporary medical benefits filed by the injured worker for medical treatment, physical therapy, referral to an orthopedist, or temporary disability benefits. These motions have to be supported by affidavits of counsel and medical records from the doctor, which specifically note the type of treatment that is being recommended and that the injured worker is demanding. General motions have to be answered within 21 days of receiving them. Then the defense has the opportunity or should schedule an exam within 30 days, and the report should be obtained within 35 days. Now, in New Jersey, there are doctors that get backed up sometimes because they're continually used, so receiving a report within such a short period of time after the exam is not possible all the time, which is why upon a showing of good cause, the deadlines can be extended. And Joe, didn't the director just recently issue a memo on this?
He did. One of the things that's happened, and it almost seemed like after the most recent presidential election, because the governor is no longer going to be apparently going to be in the new cabinet, one of the things that the governor's office has come down upon the division in and of itself, and one of the only statistics that they cover is how quickly is the turnaround time on these motions for med and temp. and they're statistically being watched, and they've given an indication to the director that they want these resolved within 60 days of the filing of the motion in and of itself. So one of the things that's happened in the past is the courts have been somewhat more liberal and loose in terms of how they've handled things. If you didn't have your answer within 21 days, but you got it within 30, they didn't really give you a hard time. Now they're, at least in New Brunswick, which is where one of his main venues is, he kind of started this experimental process in New Brunswick to try and more strictly construe the rules themselves. He did indicate that he knows that the respondent, in a lot of instances, they might be fighting some of these motions with the hand tied behind their back, because the claimant can line up their doctor and it takes as long as they need to before they can file their motion, but we are more time pressed in terms of getting an answering statement and an exam with a report in within those 35 days. Basically, he led us to believe that if you come in and you, number one, you're presenting a really good specialist to deal with the motion, and number two, as long as you have the date within 30 days, they'll a lot of times be more willing to work with you. But as we'll talk about later, one of the things that we really need to take into consideration when defending these motions is who's your adversary and who's the judge. Now, in and of itself, in terms of the specific pleadings, you need a couple different things, and when we talked before about the way that the judge and the director is now going to be enforcing these motions, there are going to be requirements that are going to be on claimants as well. And the liberal nature of it used to be that claimant's attorney could file the certification only. Now you have to have the petitioner. You have to have full medical proofs, and the medical proofs have to indicate the condition that's the problem, the type of treatment, and why the treatment or diagnostic study. If you don't have those proofs, the judge can kick that motion and it won't even get listed. In terms of the medical proofs, you have the doctor himself or herself has to substantiate why the petitioner needs that type of treatment. And one of the things that you also really want to consider, and a judge will take into consideration, is whether the expert is an actual treating physician or is it just an examining physician who often does permanency exams. In New Jersey, this case law pretty much outlines the fact that if a doctor has to put if a judge has to put physicians on a scale, that deference should be given to a treating physician's opinion instead of an examining physician's opinion. In terms of the motion for med and temp, if an allegation is that the claimant is temporarily totally disabled, they have to be able to prove that the claimant can't work. Is that contained in the medical proofs? Does the claimant indicate in their proofs why they can't work and what their job is that they can't do? In terms of the respondent's pleading, I can't stress to you enough, one of the strictures that the judge has taught, or the director has talked about, that the answering statements have to be filed within 21 days of receipt. The last thing you want to do is lose a winnable motion because you didn't meet your deadline. Make sure, especially if you have good facts, that they're placed in your affidavit and you outline it, because you want to be able to present your case on your papers to the judge ahead of time so that person can be your advocate when you go in to have your conference. If you have any supporting medical documentation that discuss things like causation or pre-existing disability or intervening accident or the claimant got hurt outside of the workplace, make sure you add that to your pleadings as well. Now, when a motion gets scheduled, usually you'll see that even if it's not an emergent motion, motions for med and temp a lot of times will jump the line. You could have a case that normally, if you saw on the court calendar, it might be out for 9 to 12 weeks. When a claimant files their motion for med and temp, it will jump up and usually be relisted within 3 to 6 weeks. When that's scheduled, the judge is going to review the motion to make sure that it meets its prima facie case. Now, that's legalese. That basically says, do you have a legitimate claim for the benefits that you're seeking, and do you have the proofs that are needed contained within the motion? When you go and you go to the hearing, usually your first listing, unless it's something that truly is emergent, you're going to sit down and you're going to have a conference and you're going to discuss the circumstances of the claim, the merits of the motion, and talk with the judge to try and strategize an end game to this. One of the things that judges will often do, if you have competing physicians, if you have the claimant's doctor who says you need XYZ treatment and you have the defense doctor who says, nah, you don't really need that, the judges a lot of times will try and get you to agree to a tiebreaker physician. If you can, usually that's by consent, and usually what you're going to try to do is make sure that you get a doctor, number one, it's as conservative as you can get, but also is going to be someone who's fairly high credentialed. Sometimes they become a little bit problematic because you have to deal with prepays and sending medical documentation to the expert ahead of time. But usually the doctors that the judges are choosing are usually pretty reputable, and they're no nonsense, and they're not going to let claims drag on forever. If you can't agree on the neutral doctor or the independent doctor, the alternate route would then be to begin trial, and that's usually within 3 weeks of that first conference.
Now, in dealing with the motions for medical and temporary disability benefits, the judge looks at a number of things. First, it's if the motion is unanswered. Again, they have the 21 days to file an answer. The motion will be granted against the employer if there's no answer within that 21 days. If the judge grants an order against the employer, you don't have an opportunity to even have your thoughts on the case heard or your defenses heard. Some judges are very liberal with regards to this. In the northern part of New Jersey, they are very strict with the 21 days that you must have it. It's 21 days, you're in court, and if defense counsel has not received the motion, but the insurance carrier has, there have been times where judges have required you, the defense counsel, whoever, to contact the insured right then and there to discuss the case because they want an answer. They want these things moved and dealt with.
So they're aggressive enough that they're actually getting in touch with you when you're not even representing the claimant?
If they know that your firm has represented them on a number of cases, they will tell you, this is here, you need to deal with it.
And frankly, that sounds like it's almost a courtesy, though, because if you're there on the 21st day and no answer's been filed, the judge technically could enter an order against you right then and there.
They're giving you an opportunity, but if you don't have an answer by the end of that day or the end of the judge's list of hearing, you're stuck. So.
And one of the things you also have to be careful of, and there have been instances where I know that judges will, if by chance the claimant's counsel knows who the employer is but might not know who the carrier is, there have been judges that have taken service against the insured as to be effective service that binds the carrier too. So if you have cases or you know that a first report of accident's been filed with your insured, make sure you keep an open line of communication with them and explain to them the fact that their actions could bind you to pick up a case that you might not otherwise want to pick up.
Now, if an answer is filed within 21 days and both parties are there to talk about it, again, in chambers, the judge will make a strong suggestion regarding a different treating doctor or an independent doctor that the parties can, come to an agreement on. If, again, the compromise can't be reached, a full trial may be necessary with all factual and medical witnesses.
Do you find that the judges in your vicinages up north, do they actually read the paperwork, or do they more rely upon your presentation?
Some judges do really read the paperwork in depth, and they will point out issues within the paperwork saying, this doctor's report says this, what do you have to dispute that, so on and so forth.
Yeah, I mean, and I think that's one of the reasons why we say that if you have good stuff, make sure that you put it in your papers, because I can tell you the judges that I appear in front of, it seems a lot of them come very, very prepared in terms of knowing where the case is going to go and where they want it to go. Also, one of the things, and I don't know if it happens up north, but I can tell you in the vicinages where I go, the judges are usually pretty liberal in trying to make sure that if they think that a claimant needs medical care, that they're going to make sure that that claimant gets it. So if you think that you have a reason why they shouldn't, rather than I just think he's treated too long, you really better have it lined up and do it as quickly as possible.
That's how they are up north as well. And then if you have to have the fact witnesses and the medical witnesses come in, then the motions for men and temp become a trial within a trial. If you have disputed facts, if you don't believe that the claimant was injured in a slip and fall, but you have witnesses that didn't see him slip and fall, saw him doing something else, and then comes into work and is lying on the ground, have the witnesses lined up ready to testify, knowing that they will have to come in and give their assessment.
Yeah, you actually, a lot of times you'll see two different types of motions for med and temp. One will be in terms of, is the petitioner getting the right care? Are they being taken care of, or are they being taken advantage of? That's one where the only real issues that you're dealing with are going to be on a medical basis. So it's going to be slightly different. When we talk about a trial within a trial, you very well could be in a situation where your whole kit and caboodle, your whole ball of wax is going to be right there. If you think that the case in and of itself is disputed because it didn't happen, technically speaking, that motion for med and temp could ultimately cause a dismissal of the claim. So that's what Vanessa's talking about. If you don't think that the claimant fell, if you have video evidence of the site where the claimant says that they fell and there's nobody there on the day and time that he says it, you're going to want to bring that to the motion for med and temp. So one of the best things that you can do on any of these, especially knowing that the judges are going to be more apt to hurt you than help you, is you want to make sure that you have as many things lined up ahead of time, so that way you're ready to go both in conference and at trial.
And that's where good investigation early on comes in. If you're aware that there's a video out there, make sure it gets to the defense counsel. The defense counsel has that, can reference it in their papers, or can present it to the judge. So that really helps in the defense of motions where it's contested as to whether or not he actually slipped and fell or had an accident.
Absolutely.
And if just the medical issues, medical treatment that are at issue, you have to have proof of those issues, but also a medical opinion from the doctor to substantiate your position. Is it an issue regarding causation of the injury, or was there pre-existing disability that is really the cause of their current complaints and not the alleged work accident?
Yeah, and one of those things that you might find is if your treating physician is giving the opinion that the claimant has all of these problems solely related to this accident, and during your investigation you're able to find out through an index or a pre-existing search through the division website, and you find out that he's got 2 or 3 other accidents that mimic the same symptoms with the same findings, you want to make sure that those documents get to the treating doctor, because basically that might give you one up going into the motion, because now you could get the opinion from the treating doctor that the petitioner's condition is not really related to the accident that you're defending, but something that pre-exists it.
In addition to knowing the judge, know the venue and your adversary. Again, certain adversaries are more likely to file more motions. They're quick to act on it. If the claimant goes into them and says, I was injured, they're not providing me treatment, or I was provided treatment but I think I need more, they'll quickly get their own exam or they'll file their motions. And they can be, seeking fees on it, because again, they're entitled to a certain percentage, which we'll discuss in a little while, of the fees for medical and temporary disability benefits paid after the filing of the motion. So they often have doctors available to immediately see the petitioner and render opinions. There are certain doctors up in the northern part of the state of New Jersey that are known to always recommend some sort of treatment for the injured worker. I don't know if they have those.
Yeah, what happens is what you'll see, and we don't mean to slam petitioner's counsel in regard to this comment, but a lot of times there are different venues, and you'll see it on the next section, where the courts almost play off on that, and they reward claimants from filing motions. So you might not get the length of time necessary to properly investigate a claim, and they might actually have it. I've had claims in the South where you'll get a letter from the attorney, and part of the motion for med and temp is they have to ask for the treatment. They can't just run out and get it. If they don't properly make the request for treatment, then technically speaking, they're not supposed to be able to make a recovery on a motion for med and temp. It has to be asked for and denied. You'll see certain instances where the claimant's attorney will send you a letter that you will get in the morning. And I actually had it where the claimant's attorney in the letter said, if you don't respond to this within 10 days, we're going to file the motion. And that afternoon, I got the motion faxed to me. So it's not fair, but those attorneys understand the system. They know the judges, they know the venues, and they know their adversaries. And frankly, it's a money generator for them. So that's one of the things when you're defending your case, to know What can you deny? Do you have a good faith basis for your denial? Do you have your ducks lined up before you go and deny it? Because otherwise, you start looking at motions and continuous motions and motion after motion that gets filed because you've authorized this, but you didn't authorize that. And those things add up after a while, and it's almost, there have been instances where the value of the attorney's fee on a motion for med and temp could actually exceed the value of the claim to the claimant.
And again, it's based on, look at the venue where the motion is filed. Some venues are more litigious, as you can see, Atlantic City, Toms River, Freehold, down in the southern part of the state. In the northern part of the state, they all are a little bit different. It depends. Sometimes you could work it out with the attorneys and the judges, so you have less of that. And again, it's important to stress, know the judge before. Judges are more apt to be liberal on treatment. They always want to find a way to treat the injured worker, make sure they get the type of treatment that they think that they need and is necessary. And a bad denial, just flat out denying the case because you don't believe the petitioner or some other issue, can lead to unnecessary costs due to possible counsel fees, unnecessary costs of having to obtain a doctor, additional treatment afterwards that you might have just been able to pay right off.
And part of that bad denial could be choosing the wrong IME doctor. If it's a doctor who has, if you know that you're going to be in front of a particular judge and that judge has previously told defense counsel that he didn't like, respect, or value the opinion of that expert, that could tie your hands because the carrier could run out, use that expert, cut off treatment, and all of a sudden you're sitting with basically a bad denial and the judge is going to rule against you on a motion for med and temp.
A good idea is to always ask the defense counsel who the judge that you're appearing before will likely recommend. So if you use that doctor in advance, the judge can see that as you're trying to do what is necessary to treat the petitioner. Now, if there are problematic issues, be prepared to present beneficial options that can soften any potential exposure to the client. Mutual opinions, non-binding voluntary tenders instead of temp. Is there a light duty position that's available that can be accommodated to help the petitioner get back to work?
So much of this, a lot of times the judges will look and say who's being reasonable and who's being unreasonable. If you go in, the other thing is a lot of times judges don't want to make decisions if they don't have to. If you can go in and present options to them that give them an out or give both sides something to work with until you can figure out the right route to go, judges are appreciative of that, not only in regard to that particular motion, but in regard to when you come back on that claim. You might end up gaining the judge's trust. So when the case comes back at the end of the case on permanency, if the judge said, hey, you were reasonable on treatment or reasonable and had a good faith reason for doing what you were doing, try to make things right, then it might save you significant permanency dollars because they might say, hey, this stays under the hump instead of going over the hump or things along those lines. So come with solutions, not just objections. All right. Now, we're going to talk about some of the impacts of motions for med and temp. We've alluded to some of it. Number one, you're going to have additional litigation expense. So when you start to think about cutting people off, realize that basically you're now looking at, you're going to have expert costs, you're going to have extra defense costs in terms of trial testimony and things along those lines. If you lose and the claimant's attorney wins, they get upwards of 20% of every single dollar that their client receives as a result of the motion. Now, there used to be a cap on counsel fees, but now that Judge Watanko is in, he's reviewed the statute in and of itself and the rules and regulations and realized that that cap that had previously been imposed by earlier administrations was arbitrarily set. It used to be somewhere between $45,000 and $50,000 per order. Now, if you end up having somebody who has a fusion surgery as a result of a motion for med and temp that goes bad and ends up having to go on lifetime pain meds or things along those lines, and it could be upwards of $100,000 or $200,000 or $500,000 or $1 million, it could be upwards of 20% of every single dollar that you pay as a result of that motion. So be really careful. One of the things that our office has been pretty successful in doing is if we know and have taken appropriate steps, we try to save our clients money in terms of the overall counsel fees. And one of the things that we've been able to do fairly well, at least in New Brunswick, is if a motion for med and temp gets filed and we're ultimately found responsible but have never had to take testimony, a lot of times you can negotiate the percentage of the counsel fee. And one of the things that we've done is we kind of have a formula. It's usually like 10% of a counsel fee if there's no testimony, 15% counsel fee if there's petitioner's testimony, and 20% if you go the trial route. But those figures in and of themselves can be negotiated provided that you have the right counsel. And again, that's why you have to know your adversary. You have to treat your adversary the right way. You have to treat the claimant the right way when you're dealing with all these issues, because if you do right by them, a lot of times they could do right by you. The other thing is, if they don't do right by you after you've done right by them, you're going to stick it to them at some point, whether it be on that case in the future or on a different case moving forward. The other thing that you should be aware, if you improperly deny or failure to abide by a court order, not only could you be responsible for the benefits that you have to provide and the 20% counsel fee, but you could be responsible for additional penalties of upwards of 25% on top of everything, as well as interest and additional counsel fees on top. So if you ever, the one thing if we can stress to you, motions for med and temp, Jersey is a pretty laid-back vicinage, but if you get a motion for med and temp, it needs action, it needs immediate action, and it needs to be stayed on top of before, during, and after. So if orders are entered, make sure that orders are followed, because if they don't, then you've got all kinds of serious ramifications. Now, in terms of possible defenses when handling a motion for med and temp, you want to make sure that as soon as that motion for med and temp comes in, whether it be to the attorney or to the carrier, that you guys are in contact with each other right out of the chute. All of your factual issues need to be discussed. All of your witnesses need to be lined up. All of your investigation, whether it be surveillance, whether it be video of the accident site, line up your ducks right off the bat, or make sure that let us know what you have to get and whether or not it's available to get. If you have this motion for med and temp and you've got 10 other things that aren't emergent, try and get to those when you can get to them. Deal with the motions for med and temp as quickly as you can. Sometimes we as defense counsel, when you guys refer us the file over, you only send us the claim petition, which can make it difficult if a motion for med and temp comes within that initial file period. So if you know that there's going to be a hot button case or it's going to be a big case, if you can get us whatever investigation, medical records, indexes that you can, so we can track down whatever materials that we think that you can use to help your defense. We talked about strong initial investigation and maintaining. Now, another thing is, when you line up your witnesses, sometimes you can line up witnesses when the case is started, but you might not have a motion for med and temp for 3 or 4 or 5 months. You want to make sure on the claim end that you as the carrier are in touch with the insured, because the last thing you want to do is have your star witness leave the employee of the company and you don't know where to find them, or miraculously their story could change if they've had a bad result as to why they're leaving the insured. So make sure that if you see things along these lines, whether it be for a motion for med and temp or a trial, but usually more so for a motion for med and temp because it's emergent, make sure that you have your witnesses in your system and you don't lose track of them. Another suggestion is, when you know that you have a difficult medical case, one of the things that we fully understand, medical are ridiculous all across the board, whether it be workers' comp, whether it be private health, whether it be personal primary physicians and personal policies. However, and we understand that in order to save costs, that sometimes the insureds themselves will have like a clinic, or the TPA or a carrier will have its own emergent care or Concentra. And those are well and good, especially for smaller cases, because they might not morph into something big. But if you think that you have something that's going to need good oversight, make sure that you get the claimant to the right doctor as quickly as you can, because the last thing you want to have is either a premature cutoff on something that turns out to be a really bad spinal injury or joint injury that's going to need to be taken care of surgically, or if you're not treating it properly, and then when you ultimately get it in the hands of the right person, that they can't fix it because the condition has become worse enough that it's no longer is likely to return to its maximum medical or pre-injury status.
And if there's questions on what doctor to direct the injured worker to, always contact the defense counsel, because we have doctors that we know up in northern Jersey that will be willing to treat the injured worker and get a treatment plan set up so they get back to work quicker, because if they get back to work quicker, there's less temp benefits paid. And I'm sure you have similar doctors.
Absolutely. And the one thing, because of our experience in the industry and our being in practice over here for 25 years, we also know who the right doctors are and the specialties that they deal with. So in certain instances, you don't want to send a person with a bad back to a shoulder specialist. You don't want to send somebody who's got bad hands to a foot specialist. So we would know who to recommend and the specialties that they deal with. So like Vanessa said, just keep in touch with us, and we'll do our best to make sure that we can help you put the claimant in the right hands. Vanessa is now going to talk about palliative care.
Is palliative care necessary? Short answer, generally no. Long answer, of course, sometimes. Again, with the chronic pain cases where there's ongoing narcotic medication and pain management from the doctor, petitioner has a chronic pain condition, that medication is necessary to allow the injured worker to plateau, to continue and prevent regression back to how they were initially after the accident. The point is to get the injured worker to a point where they can still function properly and do some sort of work. Palliative care really comes into play in psychiatric cases.
Yeah, and one of the things that's happened is over the course of time, that used to be a buzzword. And the buzzword was, as soon as a claim rep or a defense attorney would see the word palliative care, they'd say, "Ooh, that's it, because we're no longer curative." And one of the things that's happened, especially in this case that Vanessa will talk to you about, is the court basically came back and said, although the treatment itself could be deemed palliative, if it provides the claimant with enough comfort and the ability to try and lead as active a life as they can lead, then the judges find that to be curative in nature, even if it's not curative medically.
In Hanrahan, the injured worker was a police officer who suffered neck and back pain. He received treatment, and at one point the doctor recommended physical therapy. The insurance carrier said, no, that's not necessary at this point in time. However, the court said the act allowed for continued treatment, whether it's labeled as palliative or not, as long as the treatment is reasonable and necessary to cure and relieve. So in that case, the physical therapy was reasonable and necessary to cure and relieve the injured worker. And the statute requires that it cures and relieves the worker of the effects of the injury. Again, Joe alluded to that at the very beginning with the section of the statute that deals with curative. Palliative care, though, can relieve the effects of the injury when necessary, again, with the pain management or chronic pain.
Yeah, and you have to be careful with that. And that's one where you also want to work with your expert, because especially if you get into psychiatric care or pain management, sometimes that's like opening a Pandora's box. And I jokingly say, it's like trying to put the jelly back in the donut. You have to be really careful. And that's one of the reasons why you want to make sure that you have the right expert who understands the system and understands that while providing care to a claimant, that you're not letting the claimant just run away and get whatever they want without reason. And I think if you can show that you have the right expert and you're dealing with the claimant in a reasonable manner, it will end up going well with you with the court. The last thing that we wanted to talk to you about today was about cases that I'm seeing a lot. I don't know if you're seeing these in Vanessa, but on reopeners, invariably, I'm seeing two things. Number one, every single reopener, it seems like the claimant, they file the reopener application and now they're looking for treatment. The other thing that you have to be really careful of, they changed the form of the reopener. And in the reopener itself, there's a section of the reopener that is no thicker than that pen. And in it, in microscopic lettering, it usually says petitioner is in need of medical care and seeks a medical exam. When you have super aggressive attorneys, one of the things is they're now using that as the notice that they're asking for care. So if you get a reopener application, make sure that you look for that to deal with the request, because if you don't do it, that then could open the Pandora's box for them to go out and get unauthorized care or to file a motion for med and temp to seek additional fees. But I don't know, are you seeing a lot of reopeners with request for treatment?
We are seeing a lot of reopeners with request for treatment, specifically with the application, and they have it in there. Just have to be very careful to read the entire application. If they're requesting treatment, like Joe said, address it, because they will file a motion, because if you don't respond, they deem that a denial of their request.
Exactly. And the other thing that I see is, especially if the claimant continues to work there or has worked for a period of time after the settlement, I'll see the reopener application and then I'll see an occupational disability claim to go with it, kind of almost as a catch-all. And then on top of that, they'll then file a motion for med and temp. So when you see the reopener, number one, make sure that you're looking to find out whether or not the claimant's asking for treatment. Under the law, technically speaking, they have the right to come back and ask for it. They have it for within 2 years of the last time that they receive a benefit. And you'll see them predominantly on bigger cases. You'll actually see there'll be situations where you'll have people that'll have 20 and 30% of partial total, and they'll be looking for treatment within 6 months of the settlement in and of itself. So they might still be getting permanency benefits when they're seeking additional care, and they're within their legal right, as long as it's within 2 years of the last date of benefit that you provided to them, and that's medical treatment, temporary disability, or permanency benefits. Now, the one thing that you should also be aware, there's case law out there that says if you request a need for treatment exam and the carrier provides that, that is in and of itself, it does not constitute treatment. So that could impact your statute of limitations in terms of the filing of a reopener or the extension of benefits. So it's something to also take into consideration. Now, when you deal with treatment issues after a settlement, our recommendation is look on a case-by-case basis. A couple of reasons for that. Number one, was the claimant reasonable? Were they cooperative? Were they seriously injured? Or were they full of nonsense? Were they exaggerating? Did they have symptom embellishment? Was symptom magnification all over their medical treatment records and their functional capacity evaluation or your perm exam? Were they difficult? Were they someone who just wanted and wanted and wanted, and you know that they're going to be a problem? You also want to make sure that you look at all the pre-existing medical records from the earlier settlement, and then look at their relation into the perm exam. Did those records talk about the possibility of a worsening of the claimant's condition? An area that you always see worsening, if you provide spinal fusion surgery, unfortunately, it provides momentary relief. It fuses that joint and it takes the pain away because it's no longer moving and impacting nerves. But it's been medically proven that invariably, because everything else in the spine moves but for that fuse site, that ultimately the level above it and below it are going to fail. And then you're going to be dealing with those issues down the road. So if you have a fusion surgery, if the claimant is complaining of areas above and below the fusion site, that's something that you also need to take into consideration. Another one is, did the claimant, was he or she recommended for surgery? I mean, you have plenty of people that will have maybe tear a shoulder and say, yeah, I don't really want to have shoulder surgery. And they reach the point where they say, I can't deal with this anymore. Now I need to go back and possibly consider that. If you have those records that substantiate their position, then that's something that you really want to consider. However, so there are all the things that kind of help the claimant. Things for you to consider as a defense person, whether claims or counsel. Look at the index or an ISO. Look at the court system and make sure that there's no intervening accidents. I have one now. I'm fighting a motion for med and temp. Guy's on a reopener. He's on his third reopener. He doesn't work for me anymore. And miraculously, If they file the reopener application, 2 weeks later they file a motion for med and temp. The carrier, after reopening their file and sending it to us, we get the answer in. They do an index. The guy had a motor vehicle accident like 4 weeks after the settlement. So that's going to be bad for him. Make sure that if you haven't gotten the motion for med and temp, but they're looking for treatment and haven't answered reopener interrogatories, think about saying, I need an affidavit from the claimant saying that he's had no new injuries. Because that's kind of like a sworn statement. And if they find out that they're lying, you now have an impeachment tool. And the other thing that I think that I would strongly recommend is that you make sure you know what the petitioner's doing. Are they working for your insured? Because your insured's going to be your best person to be able to explain. Is that somebody who looks like they're hurting? Is it somebody who looks like they're perfectly fine? Are they able to do their job function? Are they the first person to run out of the building at 6 o'clock when it's time to punch out? So if they're not working for you, then let's find out what they're doing. Are they doing something heavier than they did before? Maybe you can get an employment file and possibly consider pleading them. The other thing is you're expert when you send them either for the return for treatment exam, or you send them for the evaluation on your motion for med and temp. The doctor will at least be able to comment on that and potentially point a finger somewhere else that might either cause somebody else to be fully responsible or to at least share in the pain of having to pay on whatever.
And to just add on, if they're still currently employed with the insured, think about getting a job description of what they're doing at this point in time and see if it's any different than what they had done prior to their accident. If they're still doing the same type of work, if they're saying, I've gotten so much worse, that might be a red flag that's raised to suggest, do they really need the additional treatment that they are seeking and demanding at this time?
Sure. And another thing is, are they working overtime or they didn't work overtime? The more they're doing, obviously it cuts against their credibility. So basically, in summation, with regard to this, although motions for med and temp are a lot of situations where you're kind of fighting with one hand tied behind your back, frankly, you do have a lot of control. You can control whether proper treatment's been given. You can control whether a proper denial or cutoff is being done. You can control whether proper investigation is being performed. And you can control which doctors are the right ones to send the claimant to, whether it be for treatment, for a second opinion to hopefully potentially cut someone off, or to defend a motion either directly or through a judge independent evaluation.
And we can't stress enough that if you have any questions, contact your defense counsel. They're there to help you, to guide you through and tell you what you need to do to defend the med temp motions.
So that's pretty much all we have today. So we want to thank you for coming out and sitting in with us. And we hope that you and your families have great holidays. If you want to know or like to know more information about our workers' comp webinar series, or you'd like to be added to the list, or you know someone who might, please contact Bisa Lindsay at the address or telephone number that's listed on your screen. So we thank you for coming out and have a great rest of your day.